everyone for great. I thank you again, Daniela, for that really comprehensive explanation. Thank you, Ayala, for those additional insights. And want to give a final chance to any of our audience members. If you have any questions you would like to ask before we start the Q&A session, please feel free to unmute yourselves or drop them in the chat. Also, throughout this Q&A session, if one of the panelists made a point or if you have a question, again, feel free to unmute yourselves or bump it in the chat. Thank you. We want to start off our questions. This is targeted more towards the legal side. So these questions are targeted towards you, Melissa, and you, Lieutenant Kinsella, as you are available to answer. And the first question is, at what age do youth stop being considered juveniles in the criminal justice system? So this is open, sort of ended to everyone. I know this kind of touches on the points that Janelle was making before on your presentation. Can employers run background checks after an employee is hired?
Happy to answer that question. So an employer, after somebody is hired, an employer is not allowed to run a background check, at least through a consumer reporting agency or private companies like the Checker company or First Advantage. An employer is not allowed to run one of those background checks unless they get authorization, signed authorization from you that they are going to run one of those background checks. Now, sometimes they can get that authorization before you're hired. Sometimes you sign a document. And it's really important when you're signing documents at your hiring that you try to save copies of the documents that you sign, which can be more complicated when the hiring process takes place online. A lot of times nowadays we sign things electronically, and once we hit OK on the electronic box, the document goes away. So ideally, when you're signing documents online, you should be saving them to your computer or taking screenshots of them on your phone so that you know what you've authorized going forward. One other thing that I want to mention is if you're ever fingerprinted for employment, which a lot of times people are, like home health aides and certified nurse aides and security guards, often you're fingerprinted either for your license or for your employment. If you're ever arrested in the future, that there's an arrest notification that's automatically sent to the employment agency that initially fingerprinted you. So a lot of times our clients who are home health aides or security guards, what ends up happening is if you're arrested after hire, and an automatic notification of that arrest is sent to your employer. And oftentimes the employer knows about your arrest the day of your arrest or the day after your arrest. And that's not because they ran a new background check. That's because the Division of Criminal Justice Services automatically notified the relevant agency of the arrest.
Yeah, that was very helpful. I just wanted to follow up with one of your points. Like you said, there is sort of difficulty in like acquiring paperwork when it's virtual, but how can you go about requiring it if it's in person? Like, how do you tastefully ask your employers if you can get a copy of the paperwork?
I think a good way to do that is to contact Human Resources and ask if you can get a copy of the documents that you signed when you were hired. Often it's Human Resources that is going to have those documents. The other thing is in terms of, this doesn't exactly answer the question, but in terms of a criminal background check, when a criminal background check is run on you by one of those private companies, you have the right to know exactly what that criminal background check said, even years after the criminal background check was run. So if you're not sure what was on that background check that was run at the start of your employment, you can contact the background check company and request something called a full file disclosure to get a copy of anything that the background check company has on you, which really is anything that the employer has on you with respect to the conviction record or the arrest record at that time.
Thank you. Sam, would you like to add any points?
Speaking on the human resources side, I do agree with Melissa. Anytime, let's just say, just for an example, we had an applicant applied, went through the interview process, was extended the offer. We ultimately list, on that offer expansion, that this, offer is contingent on a background check, just for full transparency, clarity. Once we process the background check, if it's quote unquote satisfactory, the applicant is made aware that it is made, that it is satisfactory. We do keep it on file if they ever want to look at their personnel records. That's, it'll be there. Should the background check come back with conviction or something, we do take the proper channels of notifying the employee or candidate, if you will, that ultimately this is on the background check. We did our assessment. We've decided to move forward with employment or decided not to, based on what the job is, an assessment of their qualifications. And it's very rarely that, if someone, let's just say, had a DUI and they're applying for a forklift job, like those are close. So it's a little bit like, are you going to drink while driving the forklift? But if they're applying for an office job, we ultimately don't ever even disclose that, hey, your background check came back with a DUI. We just move forward with the process. So that's what I'll add for example purposes.
Great, thank you. I sort of wanted to follow up on that point, like what protections exist in regards to running background checks or like criminal history. Like, for example, if an employee has no criminal history when they are hired, but then gets into trouble, for example, during the summer, and now has some type of crime on their record, how will this impact their employment?
So in my personal experience, and I think this is what goes back to what Melissa indicated before, like if someone got arrested over the weekend, like we would, our background check stops at the point when you are extended the offer and you get the offer. We don't get notifications that you got arrested. If the employee discloses, we can't up and, say, okay, you've gotten arrested, we're going to terminate you or anything like that. Of course, if there's a conflict of interest of some sort, where if this person was arrested for child abuse and they're working with children, where we bring in our legal counsel to handle that, to make sure we're protecting, the folks that we're serving, but not violating the rights of the employee. So we can't just up and just fire you. There's things that we need to, do to make sure that we're not breaking the law.
And the other thing that I would add is that sometimes people who are arrested after they're hired, some jobs, if they're unionized or if you're covered by a collective bargaining agreement or some kind of employment agreement where there are rules and regulations about what can happen to you after you're hired, a lot of times current employees in that way are more protected, not because of the law necessarily, but because of the collective bargaining agreement or the employment agreement that you entered into with your employer when you were hired. So I'd say that if you are arrested after hire and you're in a job that is unionized and you have a union rep, it's a really good idea to immediately get in touch with your union rep. And that's so that, for two reasons. One, it's so that the union rep can protect you as much as possible, but also so that the union rep can tell you about your responsibilities with respect to the arrest. A lot of times employees have a duty to report the arrest to the employer, especially in government related jobs. And it's so if you do have a duty to report the arrest to your employer, it's good to report the arrest, but it's even better to do it with your union rep helping you do that, so that you report it in the proper way without harming your job and also without negatively impacting your criminal case in some way.
Thank you for that, guys. I see Daniela put in the chat, can some person be fired if they are arrested, not convicted of anything, but just arrested? And I think that question was answered here between Melissa, Sam, and I see Lieutenant answered as well, if the employer finds out and you weren't upfront. So a question is, what if you're going in for an interview and you haven't been charged of the crime, but it's currently being investigated? Would you be upfront about that during the interview? Like, you don't actually have a record yet, it could go either way? Or is that something you would wait until after offer, after hired, and then when the decision or the proceedings is finished?
I mean, I don't think anybody should be talking about their criminal record during a job interview because of the Fair Chance Act.
Okay.
There's no reason to, even if the investigation was finished and you are currently being charged with a crime and appearing in criminal court, I don't think that should be disclosed during the interview. I think after the job interview, and after you're given the conditional job offer, if the employer says, we're giving you this job offer, here's the offer, and now we plan to run a background check, that's the point at which, if you have a case in criminal court, you just have to be honest in response to any of those questions and make sure that you're responding accurately. And if the question is, are you currently being charged with a crime and you are being investigated? I would answer no, because you have not been charged with a crime. I think it's important to read the question carefully and make sure you're answering accurately. That's my advice, at least. I mean, other people might disagree, but that's what I would do.
And then just a quick question following up with that. If they do need assistance with reading that document, do they have time to say, can I bring this back to you? I want to double check it. Our youth could be from 16 to 24. So just gauging their understanding of it. Maybe they want to do that with a parent, or if they have a counselor, are they able to do that?
The document saying, have you been convicted of a crime, or are you being charged with a crime?
Yes. So you said after they get offered, then it might be, here, we're doing this, that part.
I think, the employers here can answer that better, but I think that it's always fine to say, I'd like a day to look at this document and show it to my parent, for example. I'd be surprised if an employer said, no, you can't have that day. We're going to not hire you because you're taking extra time. I mean, it's if you're taking a very long time, that's different. But if it's a day, I can't imagine that an employer would say, we're not going to hire you.
They have to give you a minimum of 3 days, according to the Fair Chance Act, for you to respond to any kind of, whether a background check was run and they give you that information. You have, at the least 3 days in order to respond to that.
Great, yeah, thank you for that, both Melissa and Danielle. I don't know if you have anything you would like to add, Sam.
Very common if people have somebody to discuss with when they are given 3 days to talk to somebody, because this is a rebuttal. They want to rebut the employer's specific reason why they refuse to hire them. So I always suggest that they talk to somebody either who knows the law or who can help them in answering the employer's rebuttal. I mean, the employer's reason for denying them employment. So they have 3 days. Better use it, like Daniela said.
Just to reiterate, ultimately on the employer side, I agree with Melissa. If you want, it should be a red flag if you ask the employer, for a day or two, a business day or two, to read through something, and they say no, that's problematic. I think, 3 days to 5 days is total, with notice, is totally viable, especially, and it looks good if you actually want to take the time to sit there and read documentation, just to make sure you are understanding and asking, all the questions, because sometimes people don't consider, okay, let me just, sign or walk away, and you're under duress. And so you didn't make, a decision with a clear head. So on the employer side, at least from how I operate and have operated in human resources, if someone asks for time, we do give them a few business days if they come to us, with questions or concerns, we answer to the extent that we can essentially, but always do advise them, you know, to go over it with an attorney. And I know that line sounds cliche because most people, you know, in the day-to-day don't have an attorney, but there are resources, and that's why they need the time to like find the resources to get the answers they need.
Gears a little bit into talking like hypothetically speaking, but well, not hypothetically speaking, but in general, like why are some employees like reluctant to hire I should rephrase that. Why are employers reluctant to hire employees with criminal history, especially since like Daniela did talk about the Fair Chance Act and you all mentioned that. So why is there still that hesitancy in the workplace?
Maybe they are not aware of the law, but they are required, and it's no excuse. Ignorance of the law is not an excuse. So if they are hesitant not to hire because of the record, they can reach out to the commission. But I think they know by now. The human resource departments are well aware of employment law in the city.
Thank you for sharing your thoughts. And I think the word I was looking for was that barrier to employment is what it creates. And that is, you know, those special initiatives when we have our summer youth employment is to reach those youth who might be facing barriers to employment. So we would help you navigate the system and go and, you know, choose the route and educate you. So when you are going for employment after your summer youth internship, or you do want to pursue a certain field, you know your rights. So that way you're able to make sure you're being treated and receiving fair judgment for any opportunity.
I know as we're sort of winding down to an end, I wanted again to give a chance to the panelists to like share and reiterate what resources exist there that youth can look to and to find out more about their employment rights in regards to criminal backgrounds and criminal histories.
Sure. So my organization, the Legal Aid Society, and my project, the Worker Justice Project, we assist people who have any kind of arrest or conviction record and are in danger of being denied a job because of that record, or have already been denied a job because of their record. We have a bunch of Know Your Rights materials online, and I'll drop the links to those in the chat after I finish speaking. But I think those Know Your Rights are a really good way to start. And then if you have any further questions, you're welcome to email us or call us. And our email address, which I'll also put in the chat, is workerjustice@legalaid.org, legal-aid.org. And one other thing that I just thought I'd mention in this last comment is something that's really helpful, I think, is if you do have a criminal record that you think is going to show up on a background check, a really good idea is to, before even applying for a job or before the background check occurs, to prepare a personal statement and something that I call an accomplishment packet. So a personal statement where you talk about the conviction a little bit, then you talk about all the good things that you've been doing since the time of the offense, like school or training courses or anger management. And I think the personal statement somebody asked how long it should be. I think it can be relatively short, just, you know, a few sentences about what the offense was for, and then a longer amount about everything good that you're doing and why you'd make a good employee. And then the accomplishment packet can have copies of your certificates, letters of recommendation, anything good. But the point that I'm sort of trying to make is that ideally you should prepare this in advance, because 3 days is not a long time. And the Fair Chance Act was just amended to make that time longer, which is great, but 5 days is not a long time either. And so I think just having that in advance, either on your computer, on your phone, or print it out so that you don't have to rewrite the personal statement every single time, is really a helpful thing. And it's something that I think a bunch of organizations that help with resumes, for example, would also be really happy to help with something like that. So that's my 2 cents, and I'll put everything in the chat now.
I appreciate that, Mila. So youth workforce development, and with that population, I've never heard of that as something that we should be guiding or helping them with, because while we help you with your resume, we would assist you with that packet, that accomplishment and personal statement. I also want to note that participating in workshops and panels, that's like volunteer and extracurricular. So any youth that are present on this, you would note this down if you were doing your extracurriculars on your resume, or if you had to write a personal statement. And you also do receive the community service credit hours for all of the virtual presentations that you partake in. You would email myself and I'll drop that in the chat, or Stacy, and we could further assist you with that. Thank you.
One other thing, sorry, that I just also want to mention before this ends is for anybody who's being charged in family court, who's arrested on a juvenile delinquency and is in family court, it is 100% illegal for any employer in New York State to discriminate based on that juvenile delinquency involvement or family court charge. And it's also 100% illegal for discrimination to happen or for any inquiries about that to happen. So it's one thing if you're in criminal court, but if you're in family court, it's very clear that should never be an issue. And for criminal court, if your case ends in a youthful offender adjudication, that also for most employers in New York State, it's illegal for them to ask about or discriminate on the basis of that YO case, the youthful offender case.
I think what I'd add goes into, two sections. I think a big part of it is knowing, your rights, which there's so many, and oftentimes we simply just don't know because we aren't attorneys. We don't study the law. However, the Human Rights Commission, I always err on the side of caution. Like if there's seems to be smoke there, definitely give the commission a call to just inquire, get answers in that regard, because I think one of the things employers get wrong is that they get so hung up on the criminal background, but definitely don't even assess whether or not you can do the job. They've already arrived at the decision once they see, this person has a record. So you never even get the chance to prove yourself that you can actually do the job. You don't get to walk through that door. So there's that. And then there are lots of, organizations that help you navigate navigate these challenges. One of the things is, let's just say, even if you do go to the Human Rights Commission and you win and the employer has no choice, but to essentially take you, how are you going to feel in that organization? Are you going to be excluded? Are you not going to be afforded the same opportunities or have upward mobility? So, organizations like the Fortune Society ultimately partner with employers that really are committed to reducing recidivism. So if I could just sum it up, one, if there is smoke there, maybe your gut is right. It never hurts to just call the commission. Like Melissa said, 5 days is not enough, but to be, on defense instead of offense or playing catch up, to be proactive. Essentially, that would be the second thing. And the third part ultimately is to hold the employer accountable and making sure that they are, providing you with the documentation. And if they choose not to, that's okay. The commission will make them essentially. So that's what I'd add.
You see, we have community offices in the 5 boroughs. So we give information generally about our law, which you can all see on our website. Our legal department is in Manhattan. Years ago, we didn't have so many lawyers. We have so many lawyers now. And there are lawyers who handle conviction record, criminal record, and all other things. And just to mention, if an employer, because you file with the commission and the lawyer in Manhattan, our lawyers, take up the case and you happen to get back to the job because they do some settlement and you feel that there is some kind of form of retaliation, you can also contact the commission again, because it's one of our strongest part of the law. If somebody files discrimination, subsequently they want to retaliate against the individual because they utilize their rights. Our law protects that too, so we have lawyers. So we communicate. Any complaint that comes to us, we communicate directly to our legal departments. So somebody should not be afraid that, okay, what if I feel, if I return there, it will be a bad position. They mistreat me. No, 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 no. They can't do that. They can't do that. So you can contact us, and if something within our review we can do, our legal department can get involved as well.
Thank you.
Thank you very much.
I know too, and like some of the agencies I've worked, they also have like a whistleblower. So that is when you can report directly if something is happening, if you feel like it's in forms of retaliation, if it's just unethical. It would be, I think it's directly, and don't quote me, but it's like a whistleblower directly to their HR, and then they would investigate on that end. So let's say you were going through the Commission of Rights saying, I'm feeling like I'm being retaliated against, there might be something at the agency as well, where you go through and they investigate.
There are two ingredients in our law, from our human rights law when you read it. If you perceive somebody is treating you for discriminatory reasons, you can go, we'll refer you to the lawyer, and they will ask you detailed question, whether what you feel is under the law is protected or not, whether it's discrimination or not. So anytime the commission is open, to talk to somebody who feels he's been treated or she's feeling treated because of protected class,